This courtroom hearing takes an unusual turn when a man claiming to be a sovereign citizen refuses to appear in court in person, telling the judge he feels threatened. Instead of addressing the charges directly, he focuses on questioning the court's authority and insists that he needs factual evidence of jurisdiction before he will cooperate. The judge tries to keep the hearing on track, calmly explaining that the court does have authority over the case and that the defendant is required to appear in person. To remove any concerns about safety, the judge even offers to arrange a police escort. But the defendant refuses again, repeating that he doesn't feel safe and that the court hasn't proven its jurisdiction. As the exchange continues, the judge becomes visibly frustrated. He points out that the defendant isn't listening and is repeating arguments that have no legal basis. The judge makes it clear that the court doesn't have to prove jurisdiction in the way the defendant is demanding, and that these types of arguments won't stop the case from moving forward. Instead of arguing further, the judge decides to give the defendant's attorney time to gather the necessary discovery. He adjourns the case for 30 days, but not before delivering a firm warning. At the next hearing, the defendant must appear in person. No more delays, no more excuses. The courtroom exchange highlights a common situation seen in cases involving sovereign citizen beliefs, where defendants try to challenge the authority of the court instead of addressing the actual charges. But as this hearing shows, the legal system doesn't bend to those arguments, and sooner or later, the defendant will have to face the court on its terms.
Can you hear me?
I can hear you.
Yeah, he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't. That's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the prosecutor.
Well, the first thing I want. Okay,
you want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they send me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney. Okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say? Can you?
I'm going to send this to the assignment clerk, Mr. Lanto. That's why you get in trouble, because you like to talk and you think you know it all, and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will
Well, and
send
I
you a
just
notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Attorney, when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And
That's
then number
why we're
two.
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? I'm asking a simple logical question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
well, I feel like I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
will
thing
you
I
watch
could
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me? And then you said I'm talking crazy.
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
You said no, you said it in reverse. I said first that you're talking some crazy talk. Then I said I'm going to adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days.
The courtroom session begins with a strange and tense atmosphere. Instead of a routine exchange about charges, evidence, or scheduling, the judge is immediately faced with a defendant who refuses to appear in court in person. The man, who follows sovereign citizen beliefs, claims that he feels threatened and unsafe. He tells the court that he will not come to the courthouse because he believes the judge poses a danger to him. From the very beginning, it is clear that this will not be an ordinary hearing. The judge listens to the defendant's concerns, but he also makes it clear that appearing in person is a basic requirement of the legal process. He explains that the court cannot move forward properly if the defendant refuses to show up. The judge tries to address the safety concern directly, offering a practical solution. He tells the defendant that if he is worried about his safety, the court can arrange for a police escort. This way, the defendant can travel to the courthouse under official supervision and protection. It is a reasonable offer meant to remove any excuse for not attending. But the defendant refuses again. He repeats that he feels unsafe, and then he changes the topic entirely. Instead of discussing the charges or the next steps in the case, he begins demanding something he calls factual evidence of jurisdiction. He insists that before he can be required to appear in court, the judge must first prove that the court has authority over him. His tone suggests that he believes this demand is a legal right, and that without this proof, the court has no power to proceed. The judge tries to keep the conversation focused. He explains that the court does have jurisdiction, and that the defendant's argument is not a valid legal defense. He tells the defendant that these kinds of claims are often repeated by people who follow sovereign citizen theories, but they have no real standing in court. The judge's explanation is calm, but firm. He wants the defendant to understand that the legal system does not work the way he thinks it does. Instead of accepting the explanation, the defendant continues with the same line of reasoning. He repeats his request for jurisdictional proof and discovery. He uses phrases that sound official, but his arguments are disconnected from how real legal procedures work. The judge begins to notice that the defendant is not listening. Every time the judge explains something, the defendant responds with the same demand again. As the back and forth continues, the judge's patience starts to wear thin. He points out that the defendant is ignoring everything the court says. He explains that the court is not required to produce the type of evidence the defendant is asking for in the middle of a hearing. Discovery is something that happens between attorneys and prosecutors, not something that stops a case from moving forward entirely. The defendant, however, refuses to move on. He insists that the court must first establish jurisdiction with what he calls factual proof. He speaks as though the entire legal system must pause until his demands are satisfied. The judge recognizes this pattern. He has likely seen similar arguments before, and he understands that engaging in a long debate will not solve anything. At one point, the judge openly expresses his frustration. He calls the defendant's statements crazy talk, making it clear that the court does not recognize these arguments as legitimate. He explains that the defendant's personal beliefs about the law do not change the court's authority. The legal process will continue whether the defendant agrees with it or not. Despite the judge's direct statements, the defendant does not change his position. He keeps repeating his demands, insisting that the court must provide jurisdictional proof before he appears. The judge tries one more time to clarify the situation. He explains that the defendant has an attorney, and that attorney can request discovery through the proper channels. That is how the legal system works. The defendant does not need to handle these matters personally, and the court is not required to respond to his demands in the way he expects. But the defendant continues to argue. He claims he needs the information first. He repeats that he feels threatened and that he cannot come to court without the proof he is asking for. The conversation begins to feel like it is going in circles. The judge explains one point, and the defendant responds with the same demand again. It becomes clear that there is no progress being made. At this stage, the judge decides that continuing the argument is pointless. Instead of wasting more time, he chooses a practical solution. He announces that the case will be adjourned for 30 days. This gives the defendant's attorney time to gather discovery and prepare properly. It also gives the defendant time to reconsider his position and prepare to appear in court. But before ending the hearing, the judge delivers a strong and clear warning. He tells the defendant that at the next hearing, he must appear in person. There will be no more excuses, no more delays, and no more arguments about jurisdiction. The judge's tone makes it obvious that this is not a suggestion. It is a requirement. If the defendant fails to appear, the consequences could be serious. The judge explains that the legal system has procedures that must be followed. Personal beliefs or internet theories do not override those procedures. The defendant's refusal to appear will only make his situation worse. The judge's message is simple: show up to court, follow the process, and let the legal system do its job. The defendant does not seem convinced. He continues to insist on his demands, but the judge has already made his decision. The case is adjourned, and the next hearing date is set. The courtroom session comes to an end with a clear expectation. the defendant must appear in person next time. The entire exchange highlights a common situation seen in cases involving sovereign citizen beliefs. Instead of focusing on the charges or building a legal defense, defendants sometimes try to challenge the authority of the court itself. They demand proof of jurisdiction or claim that laws do not apply to them. But in real courtrooms, these arguments rarely succeed. Judges are trained to deal with such situations. They understand that these arguments have no legal foundation, and they focus on keeping the case moving forward. In this hearing, the judge tried to be patient at first. He offered solutions, explained the law, and gave the defendant opportunities to cooperate. But when it became clear that the defendant would not listen, the judge shifted to a firmer approach. By adjourning the case and setting a clear requirement for the next hearing, the judge kept control of the courtroom. He avoided getting pulled into endless arguments, and he made it clear that the legal process would continue. The defendant may believe the court has no authority over him, but the judge's actions show that the case will proceed according to the law. The hearing ends with that clear message hanging in the air. The next time the court meets, the defendant will have to make a choice. He can continue to refuse and face the consequences, or he can appear in person and deal with the case the proper way. Either way, the court has already made it clear that it will not be stopped by arguments that have no legal standing.